Broadcast is now starting. All attendees are in listen-only mode.
So I do a lot of workplace investigations and trainings for the state bar associations and the state civil rights division. So I'm going to give you some of the lessons that I've learned over the years, and hopefully that'll help you out. And then feel free to type in any questions that you have, and as we go along, we can get those addressed for you. So first thing that we want to talk about is, why do we conduct workplace investigations? What's the purpose of them? And really, we kind of come down to four reasons you want to make sure that when the appropriate circumstances arise, that you're conducting a workplace investigation. First, out of fairness to the employees, whether that's the complainant themselves, that they want to make sure that the investigator or the employer is looking into concerns that they're raising. That's an important reason why we conduct investigations. It's oftentimes a scary time for a complainant to come forward, and so we want to make sure that we're doing an appropriate investigation. Also, for the respondent of the investigation, if there's allegations made about an employee, it's out of fairness to that employee that we do a thorough job looking into it. Next, you conduct an investigation because there's oftentimes a decision that needs to be made. And that's a key result of a workplace investigation, is the product of that report is not to highlight the investigator's great work. Rather, it's to be an aid in decision making. From a legal perspective, especially in the claim of a hostile work environment that is becoming more and more of claims that we see across the country, you're going to want to ensure that you've conducted a workplace investigation to be able to provide that affirmative defense, and we'll talk more about that as we go forward. Finally, more and more judges and third parties that are sitting in judgment will be expecting that a workplace investigation is done, so it's important that we keep those reasons in mind. What do we see as an effective steps or characteristics of a workplace investigation? Really, these three hallmarks should be what could be characterized by any one of your investigations that you do. First, you want it to be prompt. And prompt means a prompt response from the complainant bringing forward the concerns, whether that's written or orally to a supervisor or to HR. That's the date when we look at what is prompt. Now, a lot of times the complexity of the investigation may result in the duration of the investigation lasting an extended period of time. And that's okay, so long as the circumstances warrant the delay and so long as the response to the complainant is prompt. If you've got an investigation that's the size of the Mueller report, there's no way you're going to get that done in 2 weeks. But if you've got a simple complaint, you can probably get that done in a 2-week period. The next characteristic is impartial. We'll talk more about this as we go forward, but the perception of impartiality is just as important as being impartial in an actual context. Finally, thorough. You don't want your investigation to be subject to criticism that you didn't interview enough witnesses or you didn't gather evidence on the actual allegations and the factual claims made by the complainant. So it's important to make sure we're thorough. Here's the bottom line takeaway on this one, folks, is with respect to your investigation plans, you should have an established protocol that you're following. If you conduct workplace investigations and you have never read the EEOC's guidance on hostile work environments and conducting workplace investigations in response to those, that should be the first thing you do after you get done with this webinar, is check that out. It gives you step-by-step guidelines of what the EEOC would expect as far as an effective investigation. And then also, Association of Workplace Investigators has some guiding principles that are available as well for that, to establish a protocol for you to follow. So you don't have to make this stuff up, and in fact, you shouldn't. You should rely on the experts that have established the protocols for you. So what's an effective game plan? Really, we break this down into two types of capacities. And In an ideal world, the same person is not doing both capacities, and that's one capacity is convening the investigation, deciding that the investigation needs to be done, and then what appropriate steps to take, and then separated in an ideal context. Again, some small employers, you struggle with this a little bit, but then you have somebody else who is the one that's actually engaged in conducting the investigations. And so we'll go through the rest of the time this morning with knocking out these, talking in detail about these 10 steps. So first you've got the complaint intake. Then we'll move to assessing what is the complaint. What do we need to do here? Take a minute to identify if there's any appropriate interim actions that need to be taken. We'll cover that. We're going to determine our posture. Is this the complaint against the employer, is harassment or discrimination, or is this a complaint of employee misconduct? The next step is an important one, selecting that investigator. And then the investigator and the convening official get together here and set the scope and procedures for the investigation. Then the investigator will collect some documents, refine that complaint, interview witnesses, prepare the report, and send it back to the convening official for taking appropriate action. So let's walk through those steps. First, convening that investigation. Again, if possible, there should be a separate person from the individual that's conducting the investigation. And in an ideal setting, it's not even the same person that's in the supervisory chain of the investigator. You've got the investigator kind of separate, but again, that's an ideal setting. That can't always happen. So if you're the convening official, if you're the person that says, you know what, we need to look into this further and conduct an investigation, your critical step is on that complaint intake. This is your opportunity to allow the complaining employee, whether it's harassment or any wrongdoing by an employee or even the senior management official, that might be a whistleblower type of fraud, waste, and abuse potential allegation. This intake is your one time to sit down with that person and try to instill confidence in the internal company's process of doing or the employer's process of doing an investigation. This would allow you to keep that complaint in-house, we say. And so if you want to try to avoid getting a demand letter from a plaintiff's attorney or a letter from an administrative agency or a lawsuit, the first step of convening an investigation is an important one. During this period of time, you got to focus on the empathy with the person raising the complaint. It's not a time to criticize them. It's not a time to challenge their credibility. It's a time to talk to them about what the process means and what the investigation would look like going forward, and avoid making promises that the company will take certain actions, because at this point, there's been no findings that the employer's made. Next step. You got to assess whether we need to investigate. Not every investigation is going to require a full-blown, full-court type of investigation. In order to determine the appropriate response from an employer when we look at workplace investigations, is to ask yourself this question. If everything the complainant says to me is true, would that be a violation of law, or would that be a violation of our policy? Alternatively, if what the complainant says is true, would we take disciplinary actions? Let those questions guide you. If the answer is, so you're absolutely going to want to investigate any complaint of harassment, discrimination based on any protected class, without a question. You're absolutely going to want to investigate if there's an allegation of a violation of serious workplace rule. Where you need to look at is if there's minor complaints, or if there's complaints about an uncomfortable working environment. And oftentimes we see that with, my boss is tough on everybody and I don't like his management style, or I don't like her management style. There's a change in management where the previous supervisor was friendly and soft and comfortable with the employees, created a little bit of unproductive working environment, and senior officials have put in a more task-oriented supervisor. And those are ones where you got to look at, do we want an investigation, and if so, what level do we want? Now, let me give you an example of minor complaints. I got a call one time from a company that I've done a number of investigations for, and they said, we've got another one. Oh, geez, okay, what happened? Well, we got a complaint that, and names will be changed to protect the innocent here, that Kyle keeps stealing lunch from Sean out of the company's refrigerator. And we want you to investigate that. And I said, geez, well, I don't know if you necessarily need me to come in and investigate that minor complaint. You can just sit Kyle down and say, hey, look, Kyle, but I don't know if it's true or not, but if you're eating Sean's lunch, you got to knock it off immediately. We don't appreciate, we don't tolerate that kind of conduct. If it happens again, then maybe we'll go for it. But that's the kind of minor complaints that you may not need to do a full-blown investigation. Okay, now you've identified that there is a need to investigate. Take a minute and identify whether or not there's interim protective measures you need to take. What are those? Well, first, are there things that you should do as the employer to protect people? If you've got a pretty severe complaint of a hostile work environment where it's pervasive, the conduct that's alleged to be harassing, always staring, always leering, always touching, always looming over me, and that employee who raises the complaint works directly next to, in the office next door or in a cubicle by the office of the respondent, then you may need to take some steps to protect the people involved. You may also need to protect evidence and preserve evidence. Get IT involved. You may have, your IT system may have an automatic deletion of Outlook emails after a certain period of time, and those emails might be helpful. You may have certain surveillance cameras that are recorded over themselves if they're not protected or preserved immediately. Think about those things right away. So what factors guide you with determining what, if any, protective measures are necessary? You're going to look at, if the status quo continues, what workplace disruptions will occur? Are there any physical safety concerns? Do you have a supervisor that is being accused of retaliation, and that's going to chill the investigation if the supervisor continues to stay physically present in the workplace? Those are the type of things that you would look at. And then in crafting a cure for those issues or for those factors, and the recommendation is always to try to take the least severe option that results in the path to cure the potential issue that arises. Okay. The next step, this is an important step to be able to identify what is the ultimate approach going to be here for the investigator. One is it a defensive complaint? Is the employee bringing a complaint of harassment? That's going to kind of shape not necessarily how you go about the investigation, but really kind of the questions and the substance of what you will be asking, what evidence the investigator is going to need to collect, versus a complaint of harassment. So again, we talk about the affirmative defense. It's the LRAC-Farragher affirmative defense. The employer can avoid absolute liability for complaints of harassment from coworker on coworker if the employer responds promptly to the complaints, they conduct an appropriate investigation that's reliable, and they take reasonable action based on the results of the investigation. That's going to be a necessary step to avoid liability. And folks, let me tell you, if you haven't seen how effective the Farragher LRAC affirmative defense can be, it is a complete shield to liability under the circumstances in which you can raise the defense. And so it's a very powerful defense that employers can have when dealing with hostile work environment claims. But in order to raise that defense, we got to start before the complaint's filed. You got to follow the EEOC's guidelines that I've already mentioned, and it starts by reviewing your policies. Does your prohibition on retaliation and discrimination have a statement of how employees report those concerns? Do you train on hostile work or on harassment and discrimination issues so people understand what can't be done, what shouldn't be done, and how to report instances if that occurs? Those are important elements of being able to raise that. And finally, do you practice what you preach? Does your atmosphere line up? So you may have this complaint department, but you've got that alligator sitting right out there in practice, and so we got to watch to make sure that our policies match our practices. defensive investigation. Okay. Or offensive investigation, excuse me. So we've got employee misconduct. So this is conducting an investigation is a very good way to avoid that employee's preemptive strike. What do we mean by that? We've all been in the situation where you've got an employee that's engaged in some misconduct. You're getting around to starting to investigate it or starting to take some disciplinary action, maybe even termination. And then what happens before you can pull it all together? Oh, the employee comes and files a complaint of, injury on the job, or files an unsafe OSHA complaint, something along those lines. And now you're in a tight spot. You're stuck because you've got the employee's misconduct that's hanging out there, but you've got this intervening protected activity that the employee's engaged in this preemptive strike. And now what's it going to look like? It's going to look like retaliation. So that's why you want to start workplace investigations into alleged misconduct promptly to avoid that preemptive strike. Another benefit of the offensive investigation, or the approach that you'll take with that offensive investigation into employee misconduct, is it's an opportunity to gain potential admissions by the wrongdoer. We'll talk more about this when we talk about interviewing the respondent, but it's an opportunity to make sure the employee is aware of the rule, that it's a serious violation, and kind of lock that employee in before they, as sometimes is said, lawyer up, or have somebody massage their statement instead of getting the raw truth from the employee at the beginning. All right. Next step is to select the investigator. The characteristics of the investigator are going to be important. You want somebody who's neutral, who's respectful to the individuals that they'll engage with, who is ideally well-trained, and importantly is available. If you've got the perfect person, but they are too busy with other pressing priorities from the employer, and we can't take that work off her desk or take that work off his desk or their desk, then you need to select an investigator who can move forward. It's important to understand the selection of the investigator will be scrutinized, extremely scrutinized, as evidence of what was the level of the employer's commitment to this investigation. Were they really impartial? One of the things that has come up more and more in the past post-Me Too movement is, do you consider the gender of the investigator? And that's a kind of discussion that we could talk for hours on, of the pros and cons of that. But it's something to think about to avoid any appearance of tokenism, right? You don't select the investigator based on anything of the investigator's status in a protected class. You select an investigator that is skilled and trained, and then that's your first criteria. There may be other factors that you can consider for sure, but if you don't select a trained investigator or an individual who's going to be able to complete that job, then it doesn't matter what membership of what protected class. We've already are setting ourselves up behind the eight ball. Now, I live in Portland, and I practice in Oregon and Washington primarily, although I work across the country. Every state that I've looked at, there are limiting laws on who can conduct workplace investigations. And really, there's three categories. One is internal investigators. And so that means you are exclusively employed by the employer. Exclusively does not mean I contract half-time with one company and I work half-time with another company. It is, I am exclusively employed by that employer that is asking me there that I'm doing a workplace investigation for. That's where you get into the folks in human resources, risk management, safety. Those are ideal candidates to be doing these workplace investigations. If you're going to go external, beware. Most states that all states that I've looked at say that it either has to be a licensed private investigator by the state agency that licenses investigators, or it has to be by a practicing attorney admitted to practice law in that state. I've routinely present at this point. And about 2 months ago, I had someone come to me and say, Kyle, I attended one of your workplace investigation trainings about 2 years ago, and I saw that slide number on selecting the investigator. I wasn't a licensed private investigator. I was a retired police officer, and I've gone back and I've gotten hired. Well, sure enough, I got a call from the state agency that enforces the private investigators licensing rules in Oregon, and they fined me. They fined me $5,000 because it was a violation of state law. It's actually a Class B misdemeanor in the state of Oregon as well. So I give that to you as a sense of understanding when you're selecting your investigator, make sure that they fit one of those three categories. If you're conducting those investigations, make sure you fit one of those three categories. Okay, now that you've got your investigator selected, well, let me back up. Here's a quick chart, and you've got the materials here, so you can go back and identify whether we stay internal or go external. Oftentimes, you have folks on your staff that can do the investigation, so long as they're available and they have the respect and neutrality, or at least the appearance of neutrality, in the workplace. And so this is a little chart that we've picked up along the way that kind of can help you identify when you may want to look internal, but if it's a really complicated complaint, the respondent of the investigation, so who the allegations are about, is a senior management official. If there's some pretty gnarly allegations of extreme language or touching, then you may want to look to moving the investigation to an external individual to take that on. Okay. Now that you've got it, you got the investigation, we move on to conducting the investigation. The first step between the investigator and the convening official is to get on that same page by setting the scope of the investigation. Now, my recommendation is always to start with the default that the scope of the investigation is going to be limited to fact-finding only. Investigators, especially external investigators, do not have the background, do not have the knowledge, do not have the corporate understanding of how workplace rules have been applied in the past to be able to appropriately form recommendations. Certainly non-lawyers and even lawyers, unless it's an unusual circumstance or you are intentionally making the decision that you want recommendations or legal conclusions, it should not be included in the report. I say this because you want to maintain the flexibility from a management perspective on what to do with the facts as found by the investigator. If you allow the investigator to make recommendations as far as what, if any, corrective action to take, or whether or not there was a violation of policy or law, your hands are tied by that investigator's conclusions, and you have no flexibility to take any actions you deem appropriate, the manager deems appropriate, or the company as a whole deems appropriate, because you've abdicated that authority to the investigator. If you take any steps contrary to an investigator's recommendation, that will be Exhibit 1 in a lawsuit. Now, there are circumstances for political reasons or for other reasons where you might not want to internally make the call. And so, so long as you're knowingly abdicating that authority, go for it. But just be aware that you want to make it clear to the investigator. The other thing on that scope is to identify what happens if new allegations surface. I know I'm looking into a complaint of harassment, but now it's morphing into a complaint of a wage and hour violation. It's not just that, a male supervisor harasses and picks on a female employee, but the male supervisor makes the female employee stay extra hours over and not record that time on their time card, their wage and hour issue. What do you do with those? Best practice is always have the investigator report that back to the convening official. Convening official can see if a new investigation needs to be done, unless they're closely tied. But that discussion should happen. On those, setting the scope and the procedures. Will the interviews be recorded with an audio device? What facilities are available for the interviews? Will it always be rooms at the meeting place? or are they rooms that are going to be outside of the meeting place or the workplace, excuse me. What's the investigation report going to look like? Is it a template that's filled in? Is it a format? And again, the timeline's important to identify too. I will say, feel free to, if you guys have questions, I've been droning on for a few slides here now. If you have questions, feel free to interrupt me as we go along here. I'm happy to answer your questions kind of in closer context with where it is in the presentation. That said, I'll make sure to provide some time at the end for questions should you have those as well. All right, now we've got our gone through the process. We've taken the complaint. We did a good job assuring the complainant that the company or the employer is going to provide a thorough review of the situation. You've made sure, step 2, the protective measures, that there's status quo is okay, or you've adjusted things to make sure that status quo is okay. We've gone through, I've identified what our posture is going to be. We've identified when or who our investigator is going to be, and we set the procedures. Now let's get cracking with that investigation. As an investigator, the first thing that you want to do is create an investigation outline. This is not a witness interview outline. When you're creating this outline, what you want to do is be sure to answer, what questions does my investigation have to answer? In order to do that, my recommendation is that you create 2 different documents as you're reviewing the documents related to the investigation. If there's a written complaint, and we'll talk more about kind of what investigations or what documents you may want to collect. But you want to develop a timeline of events. When was the respondent hired? When was the complainant hired? When was the complainant's performance evaluation? When was the complaint made? Any of those other key facts are important as we go along here. You'll also want to identify individuals involved. List their name, list their role. They're the respondent and the supervisor. They're the complainant and an operating tech 1 in the resource management department. It'd be helpful too, as you're going along, identifying the contact information from those folks. So that begs the question, what documents should you be reviewing? So here's a list of possible documents that the investigator will want to gather or collect at the beginning stages of the investigation. So first and foremost, what we're looking at here is, are there some sort of written complaints? In an ideal world, you have a written complaint that you can start with, but that's sometimes not the case. Other documents that you're going to want to gather is any employee policy or handbook that identifies where the violation might be. If it's the company's harassment discrimination policy, you're going to want to look at that. If there's an allegation of wrongdoing with respect to a business process, is there a procedures manual that you're going to want to look at? If you've got a large part of my practice, primarily I represent employers with represented employees by a labor organization, some traditional labor law here. In that context, if your employees are represented by a union, you need to be gathering that collective bargaining agreement. There's likely some safeguards and some procedures that are important in that collective bargaining agreement that we need to not run afoul of. An org chart's often helpful to be able to have that spatial or that recognition of how different individuals have a professional relationship with others that might be involved in the investigation here. If there's any incident reports or emails, of course, you want to get a copy of those, the individual's accounts of the situation before you're interviewing them is key. And then social media pages. Be careful about social media if you're a public employer, because we want to avoid any kind of Fourth Amendment search and seizure issues that might come up with looking at somebody's text messages or Facebook pages or those sort of things. The last thing that I find very helpful, not just because I'm an external investigator, but because they communicate so much as far as a picture tells or pictures is 1,000 words, as they say, right? So diagrams and maps of relevant locations can be very helpful. The other thing that's important is if the allegation is made that something was said or happened at a specific location, go visit that location. It will help you assess whether or not that could or could not have occurred as it's being reported to you. So it's important to have those site visits. It's extra helpful if you have visited the relevant sites before you're interviewing the employees who you need to talk to, because you can show your expertise and knowledge of that particular location during the interview. And that gives you credibility as you're interviewing the witnesses. Okay. If assessing or if the intake of the complaint is the critical step for the individual convening the investigation, refining the complaint is the critical step for the investigator. So what do I mean when I say refining the complaint? I mean, you need to identify what facts you must gather for it to be a thorough investigation. And what questions need to be answered will depend on the posture of the investigation. If you're investigating a defensive allegation, you're going to, and that's harassment, you're going to want to look at, well, what is the alleged discrimination that has been claimed by the complainant? Let's take retaliation, for example. My supervisor retaliated against me after I criticized her accounting practices. We will need to look at what are the elements of a retaliation claim. And you're not making a legal conclusion on whether retaliation occurred or not, but you need to understand what facts to collect for the convening authority to make that conclusion. So it's important to understand, okay, if it's retaliation, we need to know, was there a protected report? Was there a protected disclosure by the complainant? Did they, in good faith, make a complaint of some violation of law, rule, or policy? The respondent, were they aware? Did they have knowledge that that complaint was made or that protected activity was engaged in? Two, did the employee suffer any sort of adverse action? What harm does the complainant allege? And then finally, what's the causal connection between the protected activity and the adverse action? So those are going to be, those elements will guide you on what evidence you need to collect. If it's an offensive investigation, especially in the unionized environment, you look to the elements of just cause. 7 elements of just cause, sometimes boiled down to 4, to be able to identify, did the employee know of the workplace rule? Did the employee, could they have not violated the workplace rule? Did they violate the workplace rule? And then how have you treated violations of that in the past? Those are kind of going to be the important elements, either just cause or of the elements of a claim. There's, legal questions here as far as what are the elements of the claim. You may need to consult with legal counsel at the beginning to organize what your investigation questions are going to look like. But again, you're not making legal conclusions. You're gathering facts upon which legal conclusions can be made. If you organize the allegations of the complainant, sometimes it's hard to really dial down on what actually happened. So refining that complaint involves identifying factual claims that support a complainant's allegations. The allegations could be subject to hostile work environment. Okay, help me understand, if I'm there with you, complainant, what facts, what things are happening, who said what, who touched who where, that support those allegations. It's very important at the beginning to make sure that you have that allegations distinction from the factual claims, is you are doing a fact-finding investigation, and so you need to make sure you're digging into facts that support their allegations. And that's when you match that up with the elements of the claim or the elements of just cause, you can identify, are there missing factual claims? Yeah, the person complains that I'm treated differently than all of my coworkers, and I have suffered an adverse employment action. But is there a missing factual claim that it's because of my protected class? It's because of my military service. It's because of my gender. It's because of my sexual orientation. So you can watch for those factual claims that are missing if you clearly identify and refine the complaint. Okay. Now, the next step is moving to witness interviews. And I should say, when I review the documents, before I engage in witness interviews, I do two things that I've found that are very helpful. I'm a little OCD here, so we'll let you in a little bit of my psyche here. One is I have 3 different color highlighters. And I read the documents and I label everything that's a factual claim that I need to find in yellow. I label everything that is a document that I can collect in blue. So if somebody references an email in the complaint, that's blue. I want to go get that email. But if there is an individual I need to talk to and identify as a witness, that's green. So we go through, we've built out that worksheet, we've identified the green parties, and we're looking to develop our witness interviews here. So when we're looking to set up our witness interviews, the first thing that you got to think about is, how are the scheduling notices going to be communicated? If you're going to request to interview certain witnesses and employees, will you be the one reaching out to those employees, or is somebody else going to set that up on your behalf? If someone's going to set that up on your behalf, you should, as the investigator, should be out there controlling the message that is sent, so you are able to conduct that investigation that is impartial and thorough. I've had situations in the past where it's a sophisticated employer who I've worked with many times in the past, but had a new person that was assigned to help me set up the interviews. The individual who was supervising that person had worked with in the past and said, yep, we'll work on it. We'll take care of it as far as setting up the interviews go. Come to find out, the way that the interviews were set up is that individuals got a invite through Outlook that's a meeting with lawyer in this room. Ugh. Can you imagine the impact that that has on my potential witnesses? Are they going to be excited to talk to me? No way. Are they going to be scared to death to talk to me? Absolutely. Are they going to say, do I need my own lawyer? What is this about? Am I in trouble? And now you as the investigator, if you haven't controlled that message, you may be trying to catch up with respect to getting some credibility and developing some rapport with that witnesses. Scheduling notices are important. The next thing is offer a neutral location. Witness interviews don't need to be conducted in the workplace. Any place that's confidential and private works great. I often find meeting rooms around, don't meet at coffee shops. I don't recommend meeting at coffee shops, but if there's a library that has meeting rooms, great location. If there's private meeting rooms at an offsite location, great. Get there early as the investigator and consider the configuration of that room. Make sure that it doesn't look like you're trapping the person into that room. Ideally, you've got a couple of different exits there. Think about what will you do if the folks that you want to interview show up with an extra guest, if they show up with a spouse or a friend, if they show up with a union representative, if they show up with a lawyer. How are you going to deal with that? My recommendation is to deal with it consistently. However you deal with it for one employee or witness, deal with it with the rest of your witnesses in the same fashion. My recommendation is allow the individual to have whoever will make them comfortable present during the investigation, with the caveat that you talk with the individual guest, especially if it's a lawyer or a union representative, and introduce the interview under these terms. We're going to go through this interview. I've got a list of questions that I've already prepared. We're going to walk through those. At the end of my questions, if you have some questions, I'm happy to allow you to ask those questions, and then we'll go through those as well. So as you go along then, if you set it up that way, once the lawyer or the union rep starts interrupting you, you can say, look, we agreed at the beginning I would ask my questions, and you'll have some time at the end to ask your questions and to make your comments. So if you've got some comments or questions, let's hold those to the end. Allow me to finish my questions. The other thing allowing the union or representative or the lawyer present is the complainant or that individual can never challenge whether or not you conducted a thorough investigation. You gave their lawyer, you gave their union rep the opportunity to ask any questions that they had during the interview. You gave them the opportunity to direct you to collect any documents or other evidence, and they didn't, or they did, and you followed up with what they want. The next, when you're talking about kind of the next component of and logistics of the interviews, is scheduling the order. Typically, you're going to want to interview the complaining witness first. Make sure you get their buy-in to the allegations and the factual claims that support their allegations. Typically, you'll want to talk to other relevant witnesses, those other green marks that you've made as you've highlighted up the documents. But under limited circumstances, the allegations might not be in dispute, so you could jump straight to that respondent. That said, the respondent should always have the last word. Always give the respondent an opportunity to respond to any new allegation. Don't be afraid to follow up. We don't want the entire credibility of your report to be undermined because you didn't go back to Kyle and ask 2 questions as a follow-up. Don't let your good work be undone because you want to get the report done today instead of tomorrow. Before you meet with witnesses, you're going to want to prepare an interview outline. You're going to want to have open-ended questions related to the allegations and those factual claims. Remember, we talk about the elements of either an offensive or a defensive investigation. That should be the talking points of your interview questions. The EOC provides a list of sample questions for various claims. This is those elements that I was referring to of retaliation. It's online. It's for the federal sector EOC investigators, but it's there available for you to kind of help you identify where you can or what questions you can ask. I always ask 4 questions at the end of every interview. Sometimes they trigger another hour of questions, but is there anyone else I should talk to? Getting all of the witnesses that I should talk to. Is there anything I should collect? Emails, videos, paperwork. What did I not ask you that I should have asked you? And is there anything else you'd like to share? Asking those 4 questions really leads to a thorough investigation. Specific tips on interviewing the complainant. Confirm those factual claims. That's critical step of refining the complaint. You want to get them to buy in that these are the allegations and these are the factual claims that I have. No more. There's no more out there. You've got it all. Because the worst thing that you could do is create an investigation and the complainant says, yeah, I understand that you didn't find harassment, but what about the retaliation claim that I have too? What? Retaliation claim? Yeah, remember I asked, I made claims about this, that, and the other thing, and you didn't get the buy-in at the beginning. Next is drill down on those underlying allegations. Again, get the factual claims. I like to have questions if I see gaps start with, help me understand how you, and fill in the blank there. Ask those reporter questions. Find out who said what, where, and when it was said. How was it communicated? All of those type of things are important for you to develop a very clear understanding of what's out there as far as the complaint goes. Oftentimes, timing of the complaint is important. You can say, hey, why did you come forward now? You want to identify if this has been a long-going harassment. There might be something that's the straw that broke the camel's back. I recently had a complaint or investigation where the complainant said, my boss has been a jerk and a bully and a supervisor and sexist for so long, but I can deal with that when it's complaining about me. But the straw that broke the camel's back is when he was making inappropriate jokes about one of my coworkers' sexual orientation. That's when I needed to come forward now. So the timing of that complaint is going to be helpful. Again, ask that witness like you do, or complainant like you do with all witnesses. Who else should you talk to? Some corroborating witnesses and corroborating documents or evidence. When you're interviewing that respondent, it's important to determine, are there any procedural requirements? Look at the collective bargaining agreement. Does the individual have a period of time before you can interview them? If it's a public sector and law enforcement, there's some statutes that specifically address that as well. Oftentimes, there's a push to try to get all of the investigation done all of the interviews done in 1 week. Avoid that temptation when you're interviewing the respondent. What I typically try to do is, as I have my witness interviews outlines and I type in answers to the questions that they write, try to consolidate that all into one single outline that's eventually going to be my report before I interview the respondent. That allows me to have a document in front of me during that interview where I can say, I'm interviewing Kyle as the respondent. I interviewed Sean as the witness. He made this statement about the incident on, August 9th. And what does Kyle have to say? And I can go back and I can review the notes of what the witnesses said right in front of me. Take time to update your outline. Assure the respondent no conclusions have been reached. When we're talking about a defensive investigation, solicit responses on each allegation and factual claim. Offensive investigation, this is where I mentioned at the beginning, you can get some admissions. If the allegation is theft of employer's property, the employee denies that they stole it, you can at least get the employee to admit theft is a violation of the employer's policy. It's a serious violation that could warrant termination or severe discipline, and get them to understand, I understand you did not steal the equipment from the IT department, but you understand stealing a computer is a very serious thing that would lead to termination. Oh yeah, absolutely, I understand that. And now you get your video that shows the individual putting the computer in his bag and walking out. So you limited what you actually have in dispute to just one element in an offensive investigation instead of others. How do you document the interviews? Are you going to use an audio recording? If you're going to just take notes, make sure you're clear about who is in the room at the time. Now, I typically, I don't consider myself, and neither should you, a human lie detector, but you want to make some notes as far as the body language if that's important. If someone's getting emotional and you're not recording it. If you do record your interviews, what I've found to be a helpful tip is when you're getting to the juicy part of an interview and it's quotes that you're going to want to put in your report, just very slightly glance over to the audio recording and make a note on your notepad or in your notes, if you're typing notes, of the time, 36 minutes and 18 seconds into the interview, and then get right back and focus your attention on the witness so they know you're listening to them. They know that you're hearing them. And then you can have that flexibility to not copiously write down notes or jot down notes as fast as you can to get that quote, or ask them, hey, I know you were crying when you said that he just now when you were reporting this to me, but can you repeat what you said because I kind of missed it through. No, you can then go back later and listen to it if you're recording it. On dual, if you got two people in the room, one of them I recommend from the employer side, one of them is just a note taker and the other one asks the questions. Don't kind of tag team those. Okay. We've gotten the interviews done. We've reviewed the documents. We're ready to sit down and now write our report. There's some general principles that are very helpful, I think, for you as you go along thinking about your report. One, the investigation is done to create a record for the decision maker. And what I mean by that is your job is to find facts. And you need the relevant facts for the decision maker to have an informed decision. But it is not done for you. The report is not about you. The report is about the facts, and it's an aid and a tool for that decision maker. Next, even though it's confidential, even though it could be privileged, my recommendation is always assume everyone is going to know what's in your report. Stand by it. Be confident in it. One of the things that I learned from watching Robert Mueller be interviewed is he was confident in the thoroughness of his report. Because every question that he could be asked, he can refer right back to where it was in the report. And that's what you need to be confident that you can stand by everything you say in your report if you assume it's going to be disclosed to everyone. The last one on the guiding principles here, this is very important. Always write to the losing party, especially during credibility determinations. Here's what I mean by that. Kyle tells one version of a story, Sean tells another version of the story. I'm going to believe Sean, and I'm not going to believe Kyle in my factual findings. I will say in my report, on one hand, Kyle reported X, Y, and Z. On the other hand, Sean reported all of these things. For these reasons, Sean's account is what I find to be true in spite of Kyle's opposite report. Okay, right to the losing party. Credibility determinations are hard. Witnesses are people, and people perceive the same event differently. If you don't have to call someone a liar, don't call them a liar. First attempt to reconcile inconsistencies. If you just can't do it, if it's not a matter of, well, Kyle perceived it this way, and Sean perceived it a different way, and it could just be that Kyle's perception at the time was skewed. If that's not a possibility, then you got to make those credibility determinations and use these factors. These are factors from the Ninth Circuit and from the EEOC's guidelines of how do you make credibility determinations. This is not something that I thought was brilliant and I wanted to share with you. Again, I take the practices, protocols, and procedures from the experts, from the EEOC and from AWI. All right, so now you're looking at your report. You put it all together from top to bottom. In a full-blown investigation, here's the components that you could see in a report. Every report is not going to be the full-blown investigation. You may have some executive summaries that, or a summary of the investigation that suffices. But when I'm called in to do a very thorough investigation, I'll have an executive summary. I'll do an introduction section. And the executive summary, I should say, includes the allegations and the findings right up front. So it's the Cliff Notes version of the full report. Somebody can pick it up and in just a few minutes get a sense of what the allegations were about, the thorough investigation and impartial investigation that was done, and what the findings were, factual findings related to those investigations. Introduction section, you're going to describe the nature of the complaint. You may talk a little bit about the timing of when it came in, when you were identified as the investigator to look into this, to set the timeline up a little bit. You can provide that summary of the factual findings, again, a little bit like the executive summary, except expanded on kind of some of the evidence that was collected. Next section that you can include in your report is an investigation background. You can list, how the investigation was initiated. You can, when the complaint came in, what the evidence was reviewed, who the witnesses were interviewed. All of the witnesses were provided an opportunity to provide additional information, and some of them did, some of them didn't. Did any witness object to you serving as the investigator? All of those type of things would be included in that investigation background. Sometimes you may have an individual who you'd like to interview, and for whatever reason you can't. They're on medical leave, or they are in the military and are deployed in the reserve capacity or reserve component. State any limitations in your investigation right there. That's the appropriate spot for it. I recently had an investigation that was on the other side of a mountain range, and there was some pretty bad winter this past winter here in the Pacific Northwest, and the roads were closed a couple of times, and so my investigation was delayed by about a couple of weeks because of the road closures. It's that kind of thing that you'd identify in that investigation background section. Then move on to a factual background. This is where you talk about the workplace. Are there any cultural or procedural or work practices or processes that are relevant? You put your organizational chart in, explain the involved people, or the involved persons, explain their organizational relationship to one another. So you kind of understand, the reader can understand the context of what's going on in this workplace or what's going on with these work rules. Then you're going to want to summarize the evidence that you've collected. Typically, I like to summarize it based on the allegations. If there's multiple allegations, I start with allegation number one, and then kind of a subheading of a factual claim. So there's a hostile work environment and retaliation complaints or allegations. We'll start with hostile work environment. We'll start with one unwanted comments that were made and list how pervasive they were or how repeated they were, and then what some witnesses are saying, what the respondent said in response to the allegations of pervasive, unwanted comments that support the allegation of a hostile work environment. So kind of I'll identify what the complainant said, what the third party say, or what the other evidence that I collected said. More generally, I typically won't attribute specific statements to specific individual unless I need to in my report. Clearly, I have that later, but I won't do that. And then I identify what the respondent has to say. And that's when you get to the analysis. And this is writing to that losing party. You know, what you're going to want to do is consider both sides of the issue and assess credibility if necessary. At the end of the day, as an investigator, it's your duty to reach a finding. It's easy to say, this is a he said, or she said, they said, so I can't reach a conclusion in this. That's not your job. Your job as an investigator is a hard one. Your job is to make factual findings. Look at all of the evidence. In close calls, here's what I have found that's helpful. Write the analysis one way, finding their allegations and the factual claims are substantiated. See how it feels. Sometimes you're kind of talk yourself out of that position on a close case as you're typing it out. Sometimes you feel more confident as you're explaining your analysis, but reach a finding. And in my conclusion, it's always, I'll be available for questions later. Okay, so now we've done everything right. And a lot of employers do this. They've done everything right. And then they stub their toe because they fail to take that appropriate action, especially if the corrective action is not necessary. So let's talk about this first, though. One, you want to take action that's consistent with the findings in that report. In California, there's a case called the Cotran versus Rollins decision. Cotran stands for the principle that if an employer relies on the factual findings of a report and takes an adverse action based on the factual findings of the report, whether or not the harassment actually occurred is frankly not an issue, because the employer didn't determine whether or not, or didn't take action based on whether it occurred or not. They took action based on the report. And so if you're making your decisions consistent with that report, it's helpful to be able to clearly point to where in the report you're going to take actions. Corrective actions must be sufficient to end and prevent any harassment. And here's where employers stumble, is they take corrective action that's designed to end and prevent harassment. Oh, by the way, I should mention the EEOC guidelines has a list of what actions are options to take. And if you're looking for, well, we don't have to always go with a nuclear option of termination if we don't want to, if we think the circumstances would allow for some less severe, the EEOC guidelines give you some steps as far as what might be at least a less severe option. Whatever option that you take, it's important that you close the loop with the complainant. Go back to that complainant. You don't have to explain the details, but just say, look, we want you to know we looked into the concerns. We substantiated some of the allegations and the factual claims that you made. We've taken immediate steps to end and prevent the harassment from occurring again. If it does occur again, or if you feel you're being retaliated against because you made that complaint, come talk to us right away. We've established, hopefully, credibility with you, that we take these concerns seriously, we do something about it, and so we want you to know that, and to communicate that outcome with the employees. Okay, we're a little over on time, but I appreciate you hanging with me here. I know we had some difficulties at the start, but that's my contact information. If I've mentioned the EEOC guidelines or any of the witness interviews, outlines that are available that I mentioned, if you want them, feel free to send me an email. I will share all of those references with you. I kind of geek out over this workplace investigation stuff, as you might be able to pick up. And so if you just got any questions that you're like, oh man, I've never even heard of this, let me tell somebody, give me a call, send me an email. I'd love to hear about your investigation. So again, thank you very much for your time this morning, and I appreciate it. So I will turn it back over to Anna. If there's any questions, I'm happy to take those as well.
Perfect. We just have 2 really quick questions. The first one is, do you need permission from the employee to record interviews for an investigation?
Okay, that is an excellent question. And normally I try not to answer with a lawyer answer, but unfortunately I have to do that here. It depends. It depends on what your state law is. Some states are consent, some states are informed as far as in-person audio recording. If it is a consent state, normally the consent is just, I tell you I'm going to record those, and if you don't leave, then you've given me consent. An informed state, it just says, I'm going to tell you it's recording. The recording device is on the table or whatever it is. Then it's an informed consent, informed state is like that. So Washington is a consent state. Oregon is a conformed state or an informed state. So I hope that answered that question.
Yes, that sounds perfect. And then our second question was, can you collect personal phone records, or would that be an invasion of privacy?
Okay, collecting personnel records, there's 2 schools of thought on this. It would not be technically any invasion of privacy because they're personnel records. They're technically records about an employee, but they're still the employer's records about the employee. There's 2 schools of thoughts of whether you want to grab that or not. One is absolutely, I want to know everything to know about these employees. The other is no, you only want to know what's relevant. So you will ask as the investigator, hey, can whoever is helping you convene the investigation, can you review the personnel files for personnel records for information of whether there was a prior complaint made against this individual? Can you access the personnel records and identify when they were hired? What are their training records? Did they attend the employer's harassment training? So I tend to go with that latter school of thought. I will only access personnel records. It's not an invasion of privacy because, again, they're the employer's records, but I'll only ask for the documents that I request from their file. So that's one where I can't give you a definitive answer. Nope, it's not an invasion of privacy. If it's personnel records, sometimes employers will blend the medical files and any kind of medical leave with the personnel file. We want to make sure we're separating those out the best we can, which is, again, another reason why you might want to say, I'm not looking into the personnel file as the investigator, but I'm asking for specific documents to be provided to me from those files.
Okay, well, if anyone has any other questions, Kyle's email is up on the screen, and mine will be up on the screen shortly. I can always forward questions to him. I just wanted to take the time to thank Kyle for taking the time to present this webinar for us. We greatly appreciate it.